For joining today's session, the Access to Justice Week session on victim impact and community impact statements. Access to Justice Week is being presented in partnership by the University of Manitoba Faculty of Law, the Manitoba Bar Association, and the Law Society of Manitoba. I'm just going to begin today with a land and water acknowledgement. So between 1871 and 1906, treaty commissioners acting on behalf of the Crown signed 7 treaties with First Nation leaders in what is now called Manitoba. This land is the homeland of the Métis Nation and the traditional territory of the Cree, Dakota, Dene, Anishinaabe, Oji-Cree, and Ojibwe nations, all of whom have and had a spiritual relationship with this land since time immemorial before the signing of the treaties. The MBA represents approximately 1,600 diverse members throughout our province. Our membership includes students, faculty members, lawyers, and judges from a variety of backgrounds who gather in lands and territories, sharing the rights and obligations of the 7 treaties. We are pleased to welcome participants from the different territories across Canada. We ask each of you to consider the lands and territories on which you practice, as we acknowledge with respect and gratitude the many First Nations, Métis, and Inuit whose footsteps have marked this land for centuries. We hope each of you will take concrete steps to gain an understanding of the customary laws of Indigenous peoples in relation to these sacred lands they have lived on since the beginning of time. We also wish to acknowledge that the water we enjoy in Winnipeg comes from Shoal Lake, the lands of the Shoal Lake 41st Nation in Treaty 3 territory. And now I'm going to introduce our 3 speakers for today's session. I'm going to start with Monique St. Germain. She's a general counsel for the Canadian Centre for Child Protection, C3P, where she oversees the legal affairs of 3CP and leads initiatives to ensure victims of child sexual abuse and exploitation have an opportunity to be heard within legal processes. She has presented to a wide variety of legal and other professionals, including judges, UN delegates, and Crown attorneys across Canada. She has appeared as a witness for C3P before various standing committees in both the House of Commons and the Senate, and as counsel for C3P when it intervened in the Supreme Court of Canada case R.V. Barabash. Monique is the past chair of the Child and Youth Law section of the Canadian Bar Association and the former co-chair of the Manitoba Bar Association's Animal Law section. Kaylee Glosson has appeared as an advocate before all levels of court in Manitoba, as well as throughout Northwestern Ontario. She attended law school at the University of Manitoba and currently practices at Brodsky, Amy & Gould. She is currently secretary for the CBA MBA Criminal Justice Section and is a member at large of the CDLAM, Criminal Defense Lawyers Association of Manitoba. In her spare time, she regularly appears in the Royal Manitoba Theatre Centre, Manitoba Bar Association Lawyers Play, fundraising productions. Kathrine Basarab is a supervising senior Crown Attorney with the Manitoba Prosecutions Service. She has wide-ranging criminal prosecutions experience and is responsible for the mentorship and training of newest Crown attorneys at the Winnipeg office. She is a proud alumna of Robson Hall, class of 2008, and completed her master's in criminal law and procedure at Osgoode Hall, York University in 2020. She volunteers regularly with the local legal community's many project and is a bencher with the Law Society of Manitoba. So before we get started, I am just going to mention that all questions can be answered at the end of the session. There will be time for questions, but if you have any questions you'd like to just type in the chat if you're thinking of them beforehand, the Q&A function at the bottom will be monitored and we will address them at the end. So now I'm going to turn it over to Kathrine and start our PowerPoint.
Good afternoon, everybody. Thank you for joining us on the day before Halloween here. While Chelsea is firing up the slide deck, I did want to include a couple of disclaimers, for lack of a better descriptor. When Kaylee and Monique and I were asked to prepare this presentation, it was on the basis or understanding that the majority of attendees are not lawyers or legally trained as such, but members of the public from all different walks of life. But we recognize, of course, that the public also includes lawyers and that members of the profession may be in attendance as well. And we don't know how many folks are Manitoba based versus from other provinces, for example. So it is where possible, Manitoba focused, because this is a joint venture of the law school and the Law Society and the Bar Association in Manitoba. If we could, this is just the title page for our slide deck. If we could go to page 1, that would be great, or the following slide, I should say. So this session is essentially a 101 on what victim impact statement and community impact statements are. And for victim impact statements, it's obviously, as is indicated in the slide, a statement that's committed to writing often that is meant to assist the court in sentencing. This comes up after a finding of guilt or after somebody has entered a guilty plea of their own accord. And it comes in many forms. We'll get to the detailed descriptions of that in a moment. More often than not, it is written. It can be typed or handwritten. Sometimes there's a drawing. Sometimes people express themselves in other ways in terms of indicating the impact that the events had on their particular life. At bottom, it's your chance, the victim's chance, to describe in your own words, in your own way, the impact that the crime has had upon you and on your life. And the statement ends up being filed as an exhibit at a sentencing hearing. If we could move to the next slide, please. So in the, we're jumping around a little bit. And it's not simply something that happens. It is legislated in the criminal code that victims are able to file this type of evidence before the court. The relevant section of the criminal code is 722 sub 1. I'm not going to read it verbatim. You have the quote on the slide, but there is a paragraph in the criminal code that speaks to the fact that victims are entitled to provide this information to the sentencing judge. This legislation has been on the books since 1988. It's back in the late 80s that there was an amendment to the criminal code that brought this into being, which is not to say that victim impact information wasn't provided at all up until that point, but it's simply when it was codified that this is information that a sentencing court can receive. One of the other things that happens is that the judge presiding at a sentencing hearing is actually required to ask the prosecutor if reasonable steps have been taken to provide the victim with an opportunity to prepare a victim impact statement. And the court is even allowed to adjourn proceedings, meaning to delay them or put them off for a period of time to allow a victim time to prepare a victim impact statement if the adjournment in the end won't interfere with the appropriate administration of justice. If we could move to slide 3, please. So who can submit a victim impact statement? That too is spelled out. Goes without saying that the person against whom the crime was committed, the person that we're referring to as the victim, is an individual who is able to submit a victim impact statement. But it's not simply that person, the person that's named in the charging document that's in front of the judge. There are others who can do so. And like the slide indicates, examples include the parent of a child who was the victim of an offense, other members of a victim's family, And then in the case of community impact statements, and we're going to discuss that a bit later in our presentation, there is ability for individuals or groups that are less directly related to the named victim to provide appropriate information in appropriate cases, again, depending on the circumstances. And I think that is, we'll discuss more about community impact statements later, but it's not simply the one person who can file. It's often the case that there are multiple victim impact statements that are filed with a court at a sentencing hearing. So we're just simply trying to dispel any notions that it's a single person who would be able to do that in any given sentencing. So that having been said, I think I am going to pass the baton now to Kaylee Glosson.
Thanks, Kathrine. So I think we can move on to the next slide. So in terms of the content of a victim impact statement, again, this is in part outlined by the criminal code. I'm not going to read the section, but ultimately what happens is the code indicates that the exact style and the form and the associated rules are set by the independent provinces. And so in our case, it's obviously Manitoba. The creation is really, it's to the province to have that, to bear that responsibility. And so each of the forms from the various provinces might look a little bit different, but the content specifically allowed for in the body is basically the same. And so the content of these forms are supposed to include emotional impact, physical, financial impact, but as well as that fears of security that a victim may have. Their rules also allow for an alternate expression to draw either a picture or write a poem or provide a letter, if that assists the writer in communicating the impact in a way that perhaps just answering questions might not. And so I think I might bounce this back to Kathrine to essentially walk us through what the actual form in Manitoba looks like. Oh, I think you might be on mute.
Sorry about that. So the next two slides show what is a standard blank victim impact statement form. This is publicly available information. If you Google victim impact statement form Manitoba, the relevant website should pop up in the poll position on the search results. And apart from the cover sheet, which is simply information for purposes of easing contact between parties, meaning the Crown and the victim, the balance of the form, if it's filled out, gets filed with the court on sentencing. And the headings, there are 4 of them, starting at page 3 and through onto slide 7. You'll see the other 2 and some of the other pages on a blank form follow what is indicated in section 722 of the code. The court is able to accept information about the impact on an individual under certain subject areas, and these dovetail with what the criminal code says. So there's the emotional impact heading under 1, along with some explanatory notes, instructions, and other, information in the name of assistance. There's physical impact. There's also financial impact, and also fears for security, personal security, meaning as may be applicable. You can see on the second to last page, there's just a blank field. And this is what I was discussing at the outset in terms of there is ability within this to, for example, draw a picture, if that is the way that is best for a victim to express themselves. that sometimes happens in the case of children, for example, who may not be able to articulate in words the impact that a particular offense has had on them, but they are able to draw a photograph. And then this document, if it's filled out on this form, gets filed with the court. That's not to say that this is the only way. Victim impact information can be presented to a court at a sentencing hearing, but this is publicly available information. This is what the form looks like. If you look for it online, you will find this PDF and can have a more detailed look for yourselves at some point after the conclusion of this presentation. And now I am going to invite Monique to pick it up from where I'm leaving it off.
Okay, thank you, Kathrine. So basically, now you've got kind of the formalities out of the way in terms of what the victim impact statement form is all about. Now, a few things to keep in mind. Submitting a victim impact statement is absolutely voluntary. You may be a victim in a case and you may be asked to submit a victim impact statement, but that doesn't mean that you have to. You definitely have the choice as to whether or not to do that. And if you do submit one, and it is important to do so if there is something that you want to convey about the impact, it is unique to you. So you can express yourself the way that you want to express yourself, and you can choose what to say. There are rules, of course, and there's going to be some discussion about those rules, but try not to get too caught up in the rules. They can seem a bit overwhelming, and it's a little bit easy to get caught up in what you can't say. But what's important is to convey what you want to convey, and then you may have to adjust certain parts of the statement. But it will be helpful for you to be able to say certain things in your first draft anyway. It can be helpful to help articulate what it is that you want to see. So in terms of actually writing a statement, there's a few drafting tips I just wanted to kind of put out there for those of you in the audience who may be faced with having to write your own statement. You look at the form, you don't have to address every single heading in there. If you don't have something you want to say under financial impact, for example, you don't have to say anything. You also don't have to try to fit into all of the boxes. Like the words that you want to say don't have to fit in the 10 or 11 lines on the form that are provided. You can just do it on a Word document and attach it to the form. The form itself does need to be part of it in some way, shape, or form, but it doesn't mean that you have to confine yourself in that way. When you're preparing a written statement, you can try to approach it like a journal entry or a letter in your first draft, because it can be really hard to get started. Another thing that we know some of the victims that our organization has worked with is they might text what they want to say to a friend or to themselves to kind of help that writing process, because a lot of people are more familiar, and the sort of the writing style that they will use nowadays is texting. Our phones also give us a nice voice record feature, so you could try doing that and get that into some sort of a starter document that you can then start working with. Just remember, whatever it is that you do choose to include, there's really no right or wrong way about how you feel. How you feel is how you feel. The important thing is to think through what it is that you want to say. Now, going through this process can be really stressful and emotionally draining. So you'll want to give yourself some time to be able to do this, and just know ahead of time that it is, or it's likely to, bring up some different feelings for you, and other things that you might not have thought about when you look at sort of the form and the questions. So you might want to make sure that you have some supports available. I know Kathrine can probably talk about the victim impact, the victim services supports that can be available. Sometimes a friend can be helpful to sort of bounce off what you want to say. One thing to keep in mind, though, is that both preparing the victim impact statement and delivering it in a court statement, if in a court setting, if you decide that you're going to read it out loud, that can be very empowering also. And it can be a bit cathartic for you as the person who is delivering it. The final thing I want to point out is that the statement is submitted as a court document, but it is not just the judge who's going to be reading it. Defense counsel is going to see it. The Crown is going to see it. If you're reading it out in open court, of course, the public is going to hear it who may be in the courtroom. So just keep all of those things in mind as you're going through it. And of course, any questions that you have, there are services that are available that Kathrine can speak to later. So I pass it now over to Kathrine for the next slide.
So like Kaylee mentioned earlier, there are some content rules for these statements. And it's often helpful to discuss this in the context of an example. So I will use the hypothetical example of an assault causing bodily harm where the harm was a broken leg. Now, of course, in the course of a sentencing, if somebody has admitted that they committed this offense and caused that injury, the Crown is going to talk about, in the course of their ordinary submissions, the nature of the injury that a crime victim sustained in the course of an assault of this kind. But for the statement, it's a place where you can specifically discuss the physical harm and the injuries that you sustained as well. Physical harm might also include, for example, apart from the actual medical diagnosis, the time it took for the injury to heal, the impact that the inability to use your leg for a period of time had on your daily life. You know, broken bones take a while to heal. How long were you in a cast? Was surgery required? Are there any ongoing mobility issues? Were you unable to drive as a result of this injury, et cetera, et cetera. And then under emotional harm, again, in the context of this hypothetical example, how has the loss of mobility or related issues affected your emotional state? You know, were you having feelings of helplessness at your situation and, ashamed, embarrassed, whatever descriptor you want to use, at having to rely on friends or family for assistance with transportation, errands? And this dovetails a little bit with fear for security later. But things like, have you noticed a change in your level of comfort with, the area where this incident happened, let's say, because of the association in your mind of this event with that place, or feelings about being, now hypervigilant when you're in public, because in this hypothetical scenario, this incident happened in a public place. And different offenses impact different people differently, and that's perfectly fine. And like Monique said, if a particular heading on this form is not applicable, there's zero requirement to provide any content under any one of those headings. And if you have more to say beyond the lines on the form, it's open to you to provide that additional information. And then again, the same scenario under financial heading. Did you have to take time off of work? Were there associated, specialist appointments that required you to be away from work for a while or on modified duties? Did you have any out-of-pocket costs that maybe weren't covered immediately or at all by other sources of revenue, etc.? And that's just, for the content in words, if I can call it that. There is some ability to provide a photograph. There is ability to, provide a poem or a photo. Like I said earlier, children sometimes might not be able to express themselves in words, but are able to draw how this offense would have made them feel. A kid can't play. if it's a broken leg, like those kinds of things. Adults potentially who are neurodiverse or perhaps have some sort of intellectual cognitive challenge may find it easier to provide this information using alternate format and not follow the form in the more traditional way. It's all fine and completely allowed, provided it doesn't offend some of the content rules for the type of information that can be provided to the court from victims. I think Kaylee has the next slide. If this one says the VIS content do, the next one naturally says VIS content don't.
Thanks, Kathrine. And as Kathrine outlined, there is a lot of helpful information that can be contained within a victim impact statement that might not otherwise be available to the court. And so as defense counsel, we certainly recognize that. That being said, there are limits to the type of information that should properly be before the court. And so there are a number of things outlined on the slide that should not be contained within a victim impact statement and really is outside of the scope of one. So for instance, you're not supposed to address the offender directly. You're not supposed to criticize them. So any comments, to the suggestion that, that person's scum, or I hope he rots in hell, any kind of content like that really should not be part of a victim impact statement. You also are not supposed to talk about matters that aren't really connected legally to the matter that's before the court. And so that also includes not making any kind of comments about a particular sentence that should be imposed. That's up to a judge to decide at the end of the day. And so comments to the effect of, well, if he doesn't get the maximum sentence, or if he doesn't go away for life, then he's just going to get out and do it again. That kind of offends both kind of aspects that I was talking about in terms of talking about things that aren't before the court, or making a sentence recommendation. It also extends to, you can't be talking about perhaps other offenses. So this may be in a situation of a domestic violence type of situation. The facts need to be contained to what that offender has pled guilty to or has been found guilty of, and really shouldn't exceed facts that are outside of that. And the reality is that if the victim impact statement contains any material that it shouldn't, then the Crown Attorney can and will redact it prior to providing it to the court for their consideration. Furthermore, defense counsel can and will object to portions of it being included for these reasons. And so I suppose some people may ask, well, what's the harm in just allowing the statement to go in without editing it? From my perspective, on behalf of defense counsel, we really need to protect the record on behalf of our clients. As we've heard, these victim impact statements are and do become public record. And for an accused person, an offender, they follow them throughout their custodial sentence. And so one thing that's really important from our perspective on behalf of our clients is that, let's say an individual is sentenced to a custodial sentence going forward, and they're up before the parole board. The parole board will consider not only prior but current victim impact. And so those statements that were filed at the initial sentencing can be brought up again. And so as defense counsel, we need to ensure that only admissible content and comments are contained within them, essentially at the outset. So that's why it's so important for these victim impact statements to kind of follow certain rules and really only address specific types of content, with obviously having these kind of caveats for some creative license for expression in the way that is most suitable to the victim in particular. And so we absolutely understand that being a victim of a crime is deeply impactful, and that people process trauma in different ways and at different speeds. But again, there are certain rules and limitations in terms of the content that can be provided to the court. And it's really not up to a Crown or a defense lawyer to to just allow it all to go in before the court. There is some vetting that needs to take place in order to make sure that the record is protected. And then
I think like just one of the things I wanted to emphasize is that it's like redactions aren't done just because what can be in these documents is prescribed by law. And as lawyers, we have an obligation to the Law Society of Manitoba and as officers of the court to comply with the law. For lack of a better descriptor. And there is no discretion in that respect. I have often received victim impact statements that for completely understandable reasons, go outside the scope of what is permissible content. And I have had those difficult conversations with the writers of those documents to tell them that, I have redacted the following sentences for these reasons. But otherwise, the allowable information, if I can call it that, does go before the court the way the victim would like it to.
I think we, on the next slide, have some case law. And so, as Kathrine mentioned, we understand we have a diverse audience today, and we don't obviously know the proportion of who are lawyers versus non-lawyers. And so the point of providing this case law isn't to necessarily review it heavily, but we are providing it because it does provide some analysis that can be useful in terms of appropriate content and potential limitations of victim impact statements. And so in Manitoba, there's a recent decision called Goodman, and this case, I think, touches on the balance that needs to be struck when allocating enough court time for victim impact statements to be heard, coupled with the competing interests of ensuring that the court proceedings remain efficient. And in that particular case, over 125 victim impact statements had been filed, and ultimately around 45 statements had been read in court. And so the court commented on some of the redactions to the statements that were found to be necessary, given the circumstances of that offense. And then when we look to some of the other provinces in the case law, the Revit decision, my reading of that case is essentially a bit of a cautionary tale for defense counsel. It's a situation where a fact became in dispute. It was on appeal, but it hadn't been originally objected to by defense counsel at the original sentencing. And so ultimately the Court of Appeal of Saskatchewan dismissed that ground of appeal. However, the court does confirm that victim impact statements should not be used to assert facts that are relevant to sentencing. And I brought that up on one of the earlier slides in terms of kind of bringing in outside facts that aren't actually specific to that particular offense and what's essentially been agreed to for the purpose of that sentencing. And then the balance of the cases on this slide really talk about a lot of what's already been discussed in terms of the limitations of victim impact statements regarding content, as well as appropriate remedies when those issues come up. And then they also confirm that the duty is on the Crown to vet these victim impact statements before they're filed with the court. I would also add to that there is also an onus on defense counsel as essentially the final safety net to review them and to review them with their client prior to the commencement of the sentencing.
Just to touch on a couple of cases in this slide, you can see that they're from various provinces and some are older than others. McDonough from Ontario, it's pushing 20 years old now. It discusses, amongst other things, who is a victim for purposes of a victim impact statement, the content rules that we've already discussed, and does make some comments about the timing of receipt of victim impact statements. Ideally, these items are received in advance so everybody has time to review them and that it doesn't then cause unnecessary delays in the sentencing process. Sometimes it can't be helped for a variety of reasons, but that is something that case raised. I will say that given the fact that the Canadian Victim Bill of Rights came into force in 2015, that legislation has expanded the definition of the word victim for the purposes of the presentation of a victim impact statement in court. The Manitoba Court of Appeal has said the same in a case called Saunders out of 2015. So candidly, McDonough's a good explanatory note for all of the content rules that we've talked about, but I can't say that its definition of who is a victim would hold anymore, given the newer federal legislation. And in WT, one of the issues was that the material was received by the judge in a non-prescribed format, and the sentencing judge took a very dim view of that. Just want to reiterate that in Manitoba, you can provide the material in a non-prescribed form like a Word document, provided it otherwise complies with the content rules. It's kind of like Monique said earlier, you put your information down in a way that makes sense to you. What ends up happening is that the blank form is affixed to your document, and it sort of incorporates the form by reference. The form might be too small. There might not be enough room for what you want to say. Even something like folks being self-conscious about their handwriting and preferring to type, and all kinds of different reasons for why you might prefer a slightly alternate format in terms of conveying that information to the court. Now, the next slide brings us to Manitoba's Victims' Bill of Rights. That is provincial legislation. It has been the law, or its predecessor, as applicable since 1998. It contains a lot of information about victims' rights in general. We do not have time to go through the entire act. And this presentation is restricted to statements, so that's going to be the focus. Section 12 of the Victims' Bill of Rights provides victims with a right to certain information, provided that it is requested. And I quote it there on the slide for you. The main thing to remember is that it's not necessarily an automatic, you do have to ask, so to speak. But as a practical matter, for many offenses, there is going to be outreach by a Department of Manitoba Justice official, whether it's the Office of Victim Services or at times the Crown Prosecutor assigned to your case, or both, notwithstanding the fact that the legislation doesn't expressly mandate this. For certain offenses, it is departmental policy to do so. The first example that comes to mind is where the offense involves a death. And because more generally it's Crown policy for the Crown to reach out where it is feasible to do so. This provincial legislation also provides for things like testimonial aids, where when a victim impact statement is being presented to court. It is the writer's choice whether they want to read it themselves or not. Sometimes they might want to, but need a little bit of help. There is capacity for that within the law. Testimonial aids such as a screen that might block the victim's view of the offender, maybe a support person, maybe even a support animal in appropriate cases, are things that are available, and that's something that would virtually certainly be advanced discussed with the individual who wrote the statement, with attempts to try to facilitate that. As a general rule, courts are public places. They are open to the public, leaving aside the ability for someone to sit right next to you when you're addressing the court from a witness box. Anybody, unless there is a publication ban, and those are extremely rare, excluding the public, not just, about non-transmission of proceedings, but literally blocking people from physical entry. Those are highly rare. Anybody can have a seat in the gallery and be there, to support somebody who's chosen to attend court, to be present for the sentencing hearing where they were the victim of an offense. The next couple of slides discuss some of the policy statements that have been made by the Manitoba Prosecutions Service. We have a number of public-facing policies. All you have to do is Google Manitoba Prosecutions Service, and our homepage will come up on that search. There's a menu on the left-hand side of the website that will state, not surprisingly, prosecutions policies. It's a link that will take you to a number of office policies. Two of them in particular bear on this afternoon's discussions: the victims policy and the sentencing policy, which again, probably not a surprise because these statements are used at sentencing hearings. And the slide 14 quotes the relevant passages from those policies. And an amount of it is reiterating what is stated in the criminal code. Victims, complainants are entitled to provide the statement to the court. And the CVBR, which is the acronym for the Canadian Victims Bill of Rights that we're going to discuss in a moment, provides for community impact statements. And then within sentencing, obviously that Crowns must be aware of the rights of victims to be a part of the sentencing process, that federal and provincial legislation sets out our obligations and that they need to form part of the consideration as a case reaches its conclusion. Of particular note is the right of a victim to file a victim impact statement, including the right to be present at the sentencing hearing. So with that said, we're going to move on to the Canadian Victims Bill of Rights. It's in force we're rounding the corner on 10 years. It's slightly newer federal legislation as compared to the Victims Bill of Rights or even the paragraph in the criminal code as it relates to victim impact statements. But it also enshrines the same right as does the provincial legislation, Manitoba, that predated it by about 20 years. So for completeness, we are letting you know that this legislation exists. However, of course, because it's from Parliament in Ottawa, it applies Canada-wide, unlike the Manitoba legislation, which would be for within our province only. And then on the next slide is detailed that on the same day as the Canadian Victims Bill of Rights was enacted into law, there was a companion amendment to the criminal code that allowed for community impact statements to also be put before a judge. That's 722.2 sub 1. It's right next door to the paragraphs about victim impact statements. I've quoted the paragraph from the criminal code verbatim there. And like it sounds, community is like maybe broader than this, the single person who within the four corners of the definition of a word victim has been impacted by an offense. Certain types of offenses impact groups beyond the identified victim, or, may have been committed against an organization where the victim isn't an identifiable person in that way. And Monique is going to comment a bit more on community impact statements. Amongst other things, works at an organization that has had occasion to file community impact statements, so is well experienced with this specific area.
Okay, so basically, picking up from where Kathrine left off, The term community is used in the criminal code, but it is not defined. So it has been a term that has been the subject of discussion in case law and in court since the enactment of the provision into the code. So this isn't meant for a legal audience, so we're not going to go through all of that case law. But basically, the gist of it is that courts are prepared to give a large and liberal interpretation to the meaning of community as long as there is some sort of a commonality within the group that is being presented as a community, either of lived experiences or interests or some other sort of linkage that they have, something in common. Courts appear to be prepared to entertain that. One thing to keep in mind is that the term community is not necessarily limited or bounded by geographical restrictions. That could be the case for some types of communities, but is not necessarily the case for all. So really, as long as there are some things that they have in common. So we've got some examples on the slide. So geography is an obvious one. Everybody in a province, or people who share a certain common feature within a province or a city or a town or a part of a city or a part of a town. Maybe the community being represented are all members of a particular religion or of a particular church community, or something of that nature. Sometimes the community statements that have been filed on behalf of a particular race. And these are not necessarily in silos. So there might be a particular race within a particular geographical region, for example. There's some that may be identified as part of a recognized group, or an identifiable age group. So children under the age of 12 or under the age of 18, maybe people who are part of the senior community. And then finally, and this is the one that our organization and the statements that we file as an entity are tied more towards the victims of a particular type of crime. So that has also been something that's been accepted as part of a community, and it's all sort of in the way that you frame it up. Next slide, please. So on this slide, we've got some of the examples, and these all come from cases where statements have been actually filed in court. So one thing to think about, so on a victim impact statement, you've got the individual victim who fills out the form and who files the statement. So the statement is theirs and it goes back to an individual. In a community statement, there has to be a community representative, because the statement is being filed by someone. So there is a form. It's very similar to the victim impact statement form in terms of the way it looks and its layout. But there's a couple of additional questions in there. So for example, one of the statements in there will have the person explain how the statement reflects the community's views. So that's sort of the opportunity for the person who's filing the statement to kind of say, whether they talked to different people in order to do this statement or where they're getting the information from. The person who files as the community representative can ask to read it out, just like with a victim impact statement. That may or may not be possible, depending on how many community impact statements are filed and depending on some of those efficiency issues that were mentioned earlier. One thing, though, is that the community representative should be seen as being able, they're either a member of the community or they're in a position to be able to speak for the community. So on the slide, there are some examples of who might be a suitable community representative for a particular statement. So a particular First Nation, for example, might have their statement filed by their chief. If it's a community center, maybe the board president is the person who might file on behalf of the community center. And this isn't meant to be exhaustive or limiting. It could be somebody else, but these are just examples of who it could be. A principal on behalf of a school, superintendent on behalf of a school division. So kind of thinking about what the group is that we're talking about. And then in the bottom one is an NGO, so a non-governmental organization on behalf of a victim type or group or an identifiable age group. So for example, our organization has filed on behalf of particular victim types that we have intersections with as an organization. And we've also filed on behalf of children or children within a certain type of area or children who have experienced certain types of things. So these are just all examples. And the number of examples that somebody can come up with is really sort of not like it's as far as you can make a good argument for why that is a community and why the community representative makes sense in the context. Next slide, please. So some of you may be thinking, well, why would there be a community impact statement? What's really the point of it? So this has been touched upon already a little bit. It's really another way of conveying impact. It can be useful when, say, the victim of a crime maybe is unwilling or unable to submit a victim impact statement. It could be something that can convey different impacts than maybe the identifiable victim is going to be conveying. Keep in mind that a victim impact statement, and when you think about the types of things that get included in there, it can be very personal. The victim might have had some sort of relationship to the offender or to the location of the offense and other types of things. Whereas a community impact statement is really broader. It's looking beyond the individual and the individual impact, not to minimize the individual impact in any way, because of course that is very important, but it's rather looking at how these types of crimes or how the particular crime in general may be impacting a community. So just to give a sort of basic example, let's say you had an individual who was attacked at a bus stop. That particular individual in their victim impact statement might talk about how when they walk by that bus stop, you know, they get triggered, they're worried about being in that area, something like that. That might be something that they say in their victim impact statement. The community impact statement, on the other hand, might be talking about how members of the community are generally more cautious and less willing to go out, feel less safe at night or the time of day when the crime happened, those types of things. It's not necessarily tied to the scene of the crime. It might be more tied to the type of crime itself and how behaviors have changed within a community. So these are sort of some of the reasons and the ways in which a community impact statement can convey impacts that are perhaps a little bit broader. Next slide, I mean, sorry. So when to consider sort of filing a community impact statement. So if the crime or the crime type has affected many people beyond the direct victim, then that is perhaps a situation where a community impact statement is worth considering. When there's been broad and significant impact on the community. So sometimes you can tell that a crime or a type of crime is having a significant impact based on media reports and other things that you can see. So when you see there's a lot of sort of public dialogue and discussion about something that's happened, that might be a case that is a potential candidate for considering a community impact statement as being helpful. The community impact statement is really providing the judge with more context about how the crime may have affected the community and the people who live within it, if we're talking about a geographical based community, or how it is affecting people who maybe pay attention to that type of crime or that type of scenario. One of the places where our organization files is where the victims themselves may not be identifiable. So one of the things that we deal with a lot is online crimes against children. And in many situations, the children who are impacted by those types of crimes are not necessarily identified in the individual case. They may have been victims, but they're not identifiable. So there's really no other reasonable way to get impact information before the court except through the avenue of a community impact statement. And then if there's no direct victim, that's another opportunity where a community impact statement may make sense. Next slide. Okay, so the content rules are really basically the same as the ones that exist for the victim impact statement. So we've already talked about those things. So what you can include, or what you can't include, sorry, is not making recommendations about sentencing, not disparaging the offender, not talking about allegations that are unproven or that aren't part of the case. Those are all things that are no-go zones for the community impact statement. But basically, what you're going to do is you're going to talk about the harm or the loss that was suffered by the community, and that depends on how you're defining the community in the context of your statement, as well as describing the impact that that offense has had on the community, maybe on how they're behaving now, or maybe differences and changes that have occurred. So harms suffered could be maybe that the community has lost the use of a particular location because let's say it's a fire and now nobody can go to the community center because the community center is in the process of being rebuilt. But the impact might be a little bit different. The impact might be an overall feeling of fear, less willingness to come to the aid of others, those types of things. So basically, when you're thinking about the content rules, it's really very, very similar to the victim impact statement in terms of what you can and cannot say. Okay, the next slide. Okay, here's a case law slide. Now, I'm not going to talk about every one of these slides every one of these cases, and I believe that Kathrine and Kaylee are both going to want to jump in and say something about one or more of them. Basically, what the cases on this slide are just examples of cases from across Canada where courts have considered the meaning of community, what is admissible and inadmissible content for these types of statements, and provide some very helpful guidance for those who may be considering wanting to file one. So many of the cases that are on this slide actually involve community impact statements that have been filed by our organization. So they involve sort of crimes against children, but the ones that do not are Thoreau, Shearer, AL, and JC. So those three cases on this slide are more general and about sort of community and talking about different types of statements. I hand it over to Kathrine or Kaylee if they want to say anything else about these statements before we get to questions.
Yes, I had included AL and JC just sort of as a Manitoba example where, amongst other things, multiple community impact statements were filed at a sentencing. I'm not going to discuss the facts at length. It's a case of pretty significant child abuse originating in and around Dauphin, Swan River, Manitoba area. It's a reported decision. If anybody wants to read it, they can find it online. But it's sort of a way where it was almost, when you sort of think about it with some time to reflect, it was a very creative but important way for a community impact statement to be provided to a court. It was a case relating to a pair of infant children who were abused terribly, and one of the outcomes was that one of the local doctors ended up taking the children in to foster them, given their specific medical needs, and amongst other things, how that doctor had to reduce work practice time in a rural community that's historically underserved by medical professionals, and the impact that that had on the wider community, the very fact that she was not able to work full time as a result of caring for the children, and also impact from other medical professionals from the hospital in terms of how it affected the entire hospital community having to provide care for these individuals. So like I said with the victim impact statements earlier, it's not a one and done. In appropriate cases, it's entirely possible and welcome to have multiple statements. But there are often situations that come before the court that, affect someone very acutely, but also have broader impact. And that is what the community impact statement is intended for. Another scenario, hypothetical, an incident at a school where a student brings a loaded firearm. It's often in those kinds of cases that, you know, the school's shut down for the day. Maybe even other schools within that division are shut down for the day. And it's important to have that impact information before a sentencing judge so that there's proper understanding, even for the offender, of the impact that their conduct has had beyond like the very immediate in front of your face type of consequences that may happen to a specific person. It's often broader than that. And one of the other things is that sometimes, short of actual documentary evidence, such as a victim impact statement or a community impact statement, it is possible for that information to make its way in front of a sentencing judge nonetheless, whether it's through submissions of counsel or through the submission of other exhibits. I'm just turning to Kaylee now to see if she's got anything to add.
Yeah, I was just going to add that point is that there is another available section under the code. It's 723 sub 2, which essentially allows the court to consider, and it shall consider any relevant evidence presented by either the Crown or the defense counsel. And so there are opportunities for the court to receive information that wouldn't maybe traditionally fall under, say, a victim impact statement or a community impact statement. And an example of that case is provided in AAJT. And so in that situation, it was not a community impact statement that was filed. The judge erroneously ended up accepting it as a community impact statement, but the reality is that it was intended to be provided under essentially that umbrella category under the criminal code, and the Court of Appeal agreed that that's where it properly should have been admitted and properly received. So there are these opportunities still for some additional information and kind of a catch-all section, I would say, of the criminal code in that regard. So I think we can move on to the questions section.
I have been keeping an eye on the Q&A and I didn't see anything typed into that chat. So I'm not sure if any of the participants have any questions, but now's the time.
I do see people are raising their hands, but you can't actually unmute on this platform. So you'll have to type the question into the Q&A function or even the chat, anywhere you can type it.
We're happy to wait a few minutes for folks to do that if there are any questions. Unfortunately, with this platform, we also can't tell if, you know, there are folks, you know, busily typing away and we're just sort of pending receipt of the question or the note in either of the chats. So Well, perhaps while we're waiting for any coming questions, we can just slide into the next slide simply because it contains some helpful websites. The first is, I realize these are a hyperlink, but again, if you Google any of these titles, the relevant websites should pop up in the pole position on your search results. There's an amount of information about victim impact and or community impact statements on the prosecution's homepage that will also take you to a list of not just the two policies that I referenced in this presentation, but all of the public-facing prosecutions service policies. It may interest you to read those. Manitoba Justice Victims Services also has its own website. And again, if you Google MJVS, their website will come up. That also contains helpful information for victims and communities interested in providing statements. And the federal government also has a victims' rights fact sheet available online. Some people might be interested or wondering about process in terms of how is it that this information gets into the Crown's hands in order for it to be filed with the court. Some documents end up in the Crown's hands first. Others get sent to the court directly. For a number of criminal offenses, Victim Services automatically assigns a victim services worker to assist the victim with the court process. And in the course of that, whether or not somebody wants to fill out a victim impact statement is discussed with that individual, or possibly that individual's parents or other, relevant party that might be interested in completing a statement. And then the prosecuting attorney proceeds accordingly based on whether or not that the person wants to fill out a statement at all. I'm sure Monique can speak to the process of filing community impact statements on account of filing them from time to time with the court on behalf of C3P. As I understand, those are filed with the court directly, and I'm just going to turn to Monique a little bit in terms of the process that is typically employed with those.
Yeah, so when we submit community impact statements, we have been told by Manitoba Justice to send it directly to a particular court clerk in Winnipeg, who then receives the community impact statements, lets everyone know that a statement has been submitted, and then we also have been told to send it to both Crown and Defense at the same time. I'm not sure that all communities or all entities filing community impact statements have been told that same thing. I think that there might be some variations in terms of process, and there isn't anything published. But certainly there is, if you contact the courthouse, and there is, if you Google, there will be a phone number that you can call to get some information about filing a community impact statement from the government of Manitoba. So that number presumably will take you to somebody who will be able to help you as a member of the public figure out what you might need to do if you want to file a statement in a particular case.
And we have found out through email that it's possible the chat was initially disabled. I think that has been straightened out now. So if anybody would like to put a question in the chat, not the Q&A, let's give it a go. Admittedly, Zoom video conferencing platforms are not my strong suit. We are all doing our best.
Okay, they want, there's a question, can you email the slides to participants after the presentation? I think we could probably look into that. If that's okay with the...
Monique and Kaylee and I will have a discussion about that, I think, and then get back to everyone. I think it's if we can, we will, and if we can't, we'll let you know in terms of answering that question specifically right now. They are now coming in fast and furious on the chat in terms of the questions. I'm going to start with AC. The question reads, can offense attorney, perhaps that means defense attorney, and offender attack the victim impact statement? Perhaps Kaylee, as the defense attorney on this panel, you want to field that one?
Sure, I can. I guess in terms of, to quote, attack a victim impact statement, I think it's in the same way that, we've talked about in terms of vetting. I suppose if there's something particularly contentious that for whatever reason can't be, vetted, there is technically always the opportunity to try to produce the person to cross-examine them. I don't know of a court taking kindly to that, so that would probably not be my approach in the circumstances, but I suppose that is an option. But ultimately it would be to have a conversation typically with the Crown and to explain why certain parts of the victim impact statement might be inappropriate to be put forward.
The next question that's scrolling is a question from a Beth Forrest. Would a nurse be considered a community representative? I think I'll take this one. In appropriate instances, I think the answer is yes. It would really depend on the facts of the specific case. It's possible, but it would have to be specific to the incident before the court. Like, to the extent anything is possible, probably, but it would be highly dependent on the instant case.
I would like to add something to that. It also depends who the community is.
Mm-hmm.
So the community representative and the community are inexplicably intertwined. So if the community in the situation was, say, employees at a hospital, then a nurse may be a perfectly appropriate community representative, whereas it may be a different situation if the community is something else.
The next question states, so the question here is, can VIS be used to establish psychological harm? Whether it's a identified line item on the form itself, and whether that information is actually expressly stated in a statement by the victim, it's often the case that psychological harm is information that ends up before the court. I know that in the context of the types of statements that Monique has had occasion to file, there may be, in a general way, discussion of the harm that certain offenses may have on a certain class of people, and that includes psychological harm. The next question says, are there any rules against victims providing VIS that justify the actions of the accused or paint them in a positive light? The statements are not supposed to address the accused at all. Statements are supposed to be about how it impacted you, period. They're not really supposed to discuss other matters, and that includes negative feelings about the offender as they do positive. At the same time, sometimes that information does end up before a sentencing judge in other ways. Kaylee, is that fair to say?
I think that's fair to say. Yep. These questions are coming in so fast.
They are, and the way they're populating in the chat, I have to scroll in order to find sort of where I left off.
I will, just jump in on the issue of psychological harm. I think that there's also the piece, the victim impact statement also talks about like fear for safety. And I think that definitely, plays in part with psychological harm. If you're talking about the impact of not being able to walk in a particular neighborhood at night anymore because of fear for, what might happen. I think that there's a direct link to psychological harm in respect to aspects that are already included within the form.
The next question reads, who is responsible to assist victims to draft impact report? Is there legislation or case law that deals with such responsibility? There's nothing in any legislation about whose responsibility it is to help somebody prepare these documents because they are completely voluntary. As a practical matter, it's often the case that if there's an assigned victim services worker from the Department of Victim Services at Manitoba Justice, they will, assist people with understanding what the content rules are and possibly provide procedural help. They will not provide substantive assistance in terms of telling people what to write down. They will be able to tell people what they can't put because either the Crown will strike it out because it's impermissible content, or if the Crown doesn't catch that information, defense counsel may raise an objection to content being outside of the rules. But there isn't any legislative mandate that a specific person or class of people help a victim complete these documents.
If I could just jump in for a second, that's correct. There isn't any legislation for sure, but oftentimes depending again on the offense, and what the situation is, it's very possible that a non-governmental organization or a helping organization like the one that I come from will assist victims in better understanding what can go into a victim impact statement and explaining the process. Understandably, if you're not familiar with it, it can be a bit daunting. And sometimes it helps just to have that conversation with somebody who can explain it. Victim services workers can certainly explain it as well. But at the end of the day, the words on the paper that are submitted have to be yours.
There's a question from a member of the audience. Would this apply to any civil litigation other than criminal? Sorry, I missed the start. This is focused on criminal proceedings. The power to submit them for criminal matters arises from the criminal code. Candidly, this presentation was geared towards criminal law and not civil litigation issues. Next question, is it possible to submit a song composed by a victim as part of a VIS? I think that it would be exceedingly rare for a original song composed by the victim to be filed with the court. In almost 16 years of practice, I haven't personally encountered it. Can I say it's never happened? No. Do I think that there might be some objections from defense counsel depending on its content? Yes, that may be something that has to be litigated. It's difficult to say, frankly, because there is a pretty wide berth in terms of providing impact in ways other than simply written or typed paragraphs. And so it's perhaps a deeply unsatisfying answer, but I think I would have to land on it depends. I don't know if Monique or Kaylee, you have anything to add for this question.
I have not personally seen a song submitted as a victim impact statement. I think I share your sentiments.
I would say I've not seen it either, although from my point of view, I don't see that that's terribly different from submitting a poem.
Right.
Again, though, it comes down to the content rules in terms of what's permissible.
One of the case law slides under victim impact, the Berner case, it's 2013 from the British Columbia Court of Appeal. It was a case where a sentencing judge accepted both a photo and then also a video of the deceased child victim singing Christmas carols with other children. On appeal, the photo was ruled permissible for due to other paragraphs in the criminal code, but the video was excluded. It's not a perfect parallel. There are, lawyers will always say that there isn't, any two case where the facts are identical. It's the only reported decision I was able to locate where there's reference to filing or attempt of filing of a video of this kind. It's happened in other cases. Most recently, there was one where the prosecuting attorney, and this was presumably with defense counsel's consent, there was a victim impact statement that was a video of a victim who was deceased. I know that was a filing in a recent court case. I really do think it would depend on the content a lot more than the form, given the wide berth there is for form within the victim impact statement form itself.
There's also a recent case, and I don't remember the citation right now, but it's like within the last 6 months, where a community impact statement included in part a video of something from within the community, and it was litigated, and in the end, it was admissible in the context in which it was submitted, which was as part of a CIS, because it was a way in which the community was expressing the community impact. So these types of statements can be creative, and certainly the case law is evolving on this point. But at the end of the day, it does come down to what is going to be permissible in terms of the content itself.
The next question is posed to Monique, so I'll leave it to her to perhaps reply.
Yeah. So the question is, how are you informed about a case in order to provide a CIS? So our organization, we advocate, and obviously all of our work is devoted towards victims of child sexual abuse and exploitation. So we closely monitor what is happening in the courts through a variety of different means, including media, case law reports, and other things. And we do active outreach to the courts, to the Crown attorneys who are handling the cases, to say we are interested in submitting a community impact statement should this get to that sentencing phase. So we'll hear about things actually early on when there's an arrest, those kinds of things. That's when we put it on the radar.
The next question is, can someone else write a victim impact statement for you if you tell them what to say? I think in a technical sense, yes, but I'm going to explain my answer. If you're physically unable to write and somebody else is doing that for you, it's, understood that it's going to be your signature or, other attestation that those are your words and not the words of your scribe. More broadly, though, and this is sort of back to the examples of who might be in a position to provide a victim impact statement, a parent of a child who's a victim can talk about the impact on them of seeing their child behaving in certain manners or, exhibiting certain things in the wake of the commission of an offense, for example. Hopefully that answers that question. I don't know if anyone else wants to add.
If I could there's one thing I will say, and that is that for some people, it can be incredibly difficult to put pen to paper. So perhaps they're at an education level that makes it really hard for them to express themselves in written form. And in that case, sort of, sitting with somebody and having them, again, it has to be your words, but having them write out for you what it is that you want to say is a way that somebody can then access. It's an access to justice issue, really, because the person themselves wants to be able to express themselves, and you have to find a way in which they can do that. So one of the things that I think has been explored in some cases and has been done in some cases is for the victim to have a video victim impact statement where they're just speaking, because that is the way in which they want to communicate. So that is possible. but it may not be without there being some debate between Crown and defense around what's admissible, what's not, what's the form, all of those kinds of things.
The next in the rolling chat is, I think, referencing a question that was posed earlier. I see that we only have 6 minutes left, so I do apologize, but I think in the interests of time, we're going to move on to some of the other questions because we want to try to answer them as much as we can within the time we have available. The next question posed is, have you ever encountered a situation where a victim requested to withdraw a filed victim impact statement for personal or other reasons before sentencing? Is this even possible? If it's before sentencing, if the document has not become a court exhibit, scenario, a victim has written a statement, it has been provided to the Crown Attorney, the sentencing is a month away, a week before the scheduled sentencing date, the victim contacts the Crown Attorney and tells them, I don't want this filed. I've changed my mind. I can't attend. I can't go through with being, in the same room as the offender, et cetera, et cetera. It is the victim's choice whether or not to file it up until the, moment of truth, so to speak. If they've written one and somebody's called me and said that they don't want to anymore, I'm not filing that as an exhibit. If they call a month after sentencing's concluded, we can't undo the fact that it's now a court exhibit. It's been filed. The sentencing is concluded. The sentencing judge can't go back and unexhibit it, so to speak. Hopefully that answers that question. And the chat scrolled up again. The next question, is there a process or mechanism for victims and communities to provide impact statements to the department or courts where charges do not proceed or result in a finding of guilt? The statements of the kind that we have been discussing relate to when there are criminal proceedings instituted and the mechanism by which that information can be put in front of a sentencing judge for purposes of having it considered at the sentencing stage. If a charge is stayed, it's, in court, let's say, it's not the case that a statement will get filed even though the charges were dropped. In terms of other mechanisms or perhaps, advocacy that other groups may want to do, it's, up to that group at that point, to sort of seek their counsel with respect to how to advocate for their organization, for example. But if there is no court proceeding, a document isn't being filed as an exhibit, it's not being considered in that way. I don't know if either of the other two panelists want to weigh in on that one.
No.
Okay. And then I think this is going to have to be our last question because we're really up against it for time. Do you find that victims or community members typically need support from their lawyer, a counselor, to help them share their experiences in a way that feels safe and empowering for them in their statement? What kind of support are generally needed? That's difficult to answer. I can only speak almost from anecdotal experience. If it's the case that people have a difficult time completing a statement, they may or may not let the Crown Attorney know that is the case. In terms of what kinds of supports that are generally needed for somebody in order to, facilitate or assist them with completing a statement, that varies by the individual. Some people might not need any at all. Some might need a little bit, some might need a lot. So again, probably deeply unsatisfying, but I think the answer in terms of what kinds of supports are generally needed is it depends. There is some available via victim services in terms of, they know the channels, so to speak. If somebody has vocalized to an assigned victim services worker that they want to complete a victim impact statement, they will be able to get a hold of the prosecuting attorney to make them aware that that's the case, and then assist with the document getting to the right places. Perhaps Monique, if you have anything to add.
No, only to echo exactly what you said. Different individuals have different experiences. We have worked with victims who are highly sophisticated and they just need a little bit of information about, what's the form, how do I do it, where do I submit it, and that's all they need. And then you have other victims that are they have a lot of questions about the criminal justice process in general, and to understand how the statement's going to be used and why they need to do it and everything else. So it really, really depends. And the nature of the crime is also a big factor. So crimes that involve crime like interpersonal violent crimes, sexual crimes, the victims of those types of crimes may need more support than of other types of crimes.
And we are now at 1:30 p.m., which is time for this presentation. I'm going to ask for Chelsea to kick it to our last slide. Thank you for your participation, everybody. We were very pleased to see the number of participants here this afternoon. We hope everybody has a good rest of the day. Happy Wednesday to all. And goodbye.
Bye.